Well, good morning, everybody. This is Diane Ewing, Vice President of Marketing and Business Production at Hoffman Brown Company. Thanks so much for your attendance at our webinar today. We'll get started in just a minute. I just wanted to say how happy we are to have you attend our anti-harassment training webinar in partnership with Symmetry HR Outsourcing, formerly known as RSJ Swenson. So if you've taken this training with us in the past, it's the same company, just a new name. So as mentioned in our invitation, this training satisfies the requirement of Senate Bill 1343, which requires all employers with 5 or more employees to provide anti-harassment training to all employees every 2 years or within 6 months of hire. Initially, the requirement was for this training to be completed by January 1st, 2020, but because it's just a crazy year, that deadline was extended to January 1st, 21. We're grateful to our partners at Symmetry HR for continuing to make this training available to our current and future Hoffman Brown clients free of charge. Because we all know if we have to have attorneys do it, it's very expensive. So just a reminder, this morning's training is 1 hour and is intended for non-management and non-supervisory employees. We're offering the required 2-hour training for managers and supervisors next Wednesday at 9:30. But you only need to attend one webinar depending on your job status. If you're attending this training as a group, we suggest that you have a sign-in sheet so that you have a record of everyone who attended. If you're attending the webinar from outside your workplace, which I assume many of us are, please be sure to send your manager the confirmation email that you're going to receive at the end of the webinar. There will be no certificates of completion given, so your follow-up email is your confirmation. And I'll just repeat that one more time because we get a lot of questions about this. There will be no certificates of completion given at the end of the training. So everyone's phones are in muted mode. We won't be able to hear you, but because the training's interactive, we encourage you to ask questions. And to do this, just go to the GoToWebinar panel in the upper right-hand side of your screen, and you'll see the box where you can type in your questions. From past experience, we expect there'll be a lot of questions, so Devin will try to answer as many of them as she can. And the follow-up email that we're going to send you afterwards will also have Devin's contact info so you can reach out to her afterwards if your question didn't get answered. All right, now down to business. We're thrilled to have Devin Deshala of Symmetry HR Outsourcing hosting today's presentation. Devin has been with Symmetry for more than 3 years, and she's hosted many of these trainings for Hoffman Brown. Also, Devin's the mother of a 3.5-year-old daughter, and she and her husband are very into fitness. They've had to become a little creative this year in keeping fit, but Devin mentioned that she's run the LA Marathon 4 times, so that's very inspirational. Devin and her family also love to travel, and they love Disney, but again, just like the rest of us, they're having to find new and different ways to experience the things they do. Devin is a human resources consultant and joined Symmetry after more than 14 years with the Department of Veteran Affairs Greater LA Healthcare System, where she rose all the way to Interim Director of Employee and Labor Relations, overseeing more than 5,000 employees. She has detailed knowledge of the ins and outs of human resources, as well as both federal and state labor laws and issues, and of course, the new COVID-19 related issues and how they relate to the workplace. So without further ado, I will now turn it over to Devin.
Good morning, everyone, and thank you, Diane, for that lovely introduction. Yes, all of my passions this year have gone out the door with 2020, but I am thrilled to be here today to talk about a topic that I'm really passionate about, in addition to talking about a topic that is not COVID related for once, which is such a nice change of pace. But I'm sure all of you can imagine prior to 2020 that what was in the spotlight, especially with workplaces, was this not new issue, but it was the concerning issue of harassment. And it started in 2017 with various allegations in the media. And it made employers and organizations realize that this was still a very prevalent issue on the work sites or in the work sites and with their employee population. And as a result, legislation has changed and tightened because it's time for us as employees, it's time for us as organizations to really change this course and make sure that our work sites are free from harassment, and that for you as employees, that you work either on-site or remote these days, but in an environment that is safe and productive and effective. So today we're going to talk about a myriad of things, looking at the legislation that has led us to this training today. We're going to talk about topics and types of harassment, and we'll talk about what you as employees should do or shouldn't do. So with that, here's a quick overview of today's seminar. So again, we'll talk about California's non-harassment training requirements, which, as Diane mentioned, has changed recently. We'll look at the federal and California's definition of unlawful sexual harassment. They're very similar, but it's important that we look at both. Once we've defined what sexual harassment is, well, then how do we spot it in the workplace? What does it actually look like? So we'll talk about the 5 different types of harassment so that you can be more aware and better identify if you experience it, which hopefully you don't, or if you witness it. We'll talk about, well, who is protected from harassment? Is it just employees, or does it extend beyond that? Does it extend to customers or visitors or applicants for employment? And one of the most important parts of this seminar today is to look at both the employer obligation. So what does your organization need to do in terms of not just correcting harassment that has occurred, but also trying to prevent it, and also your obligation. So a lot of times employees think it's not my responsibility. That's what managers and supervisors are paid for. But you as an employee also play a role in this, in trying to maintain a safe work environment. So what is your role as an employee? We'll look at an employee's right to file. So even if management does everything right, even if employees do everything right, we try to create these safe environments and sustain them, harassment sometimes can still occur. And if it does occur, what does an employee need to do? How do they report it to management? And if management does not act appropriately, what's the recourse that an employee has? Can they file a formal complaint with the state or federal government? And the answer to that is obviously yes, and we'll talk about how to do that. We will look at some important statistics that, again, really drive home that this is still very much a prevalent issue, and something that we need to, even in the midst of COVID, where we've shifted our focus from everything else directly on how to combat this pandemic, it's still important for us to pay attention to this and to take action against this. And then finally, the last few topics that we'll look at are abusive conduct. Prior to sexual harassment, this was the hot topic in the media. Slogans like bullying, it's not just in schools. So what is abusive conduct, and is it a form of harassment? And then finally, retaliation. Retaliation is the idea that if you as an employee have raised concerns, filed a complaint, and then you feel as though your organization or company has taken negative action against you, is it because you raised that complaint? And so that's retaliation. And again, are you protected from it, and what do you do if you feel you've experienced it? And finally, we're giving you all this information in a PowerPoint, and you're listening to someone that you can't see, right? So it's all this information, but how do we take all of this and apply it in your actual work environment? Now, this is the first time I've taught this seminar since the shutdown, and where a lot of businesses, maybe most of businesses that I'm speaking to today, have shifted to remote worksite. So I'm going to try throughout this presentation to also incorporate how this impacts employees who are at home. But I do really want to highlight that it doesn't matter if you're on site or working virtually at home or home office or outside in the park, wherever, these rules, this entitlement as an employee to a safe environment carries over. There are a lot of challenges that come with working remotely, right? There's a lot of interesting news stories out there right now about Zoom faux pas, right? I have been one of those where I've accidentally thought that I had my camera off and was still in my pajamas and didn't, and that's a mild case. There's definitely other cases where Zoom has gone awry, but we have to be mindful of that, that now there's all this technology and we're in the comfort of our home, and we have to remember, even though we're in the comfort of our home, that we still maintain that level of professionalism when we're working, when we're dealing with clients or employees and coworkers. And that's difficult because we had done a really good job as a society, I think, of defining that professional behavior when you walk through those office doors. And you come home and you let your guard down. Maybe you say things that aren't as kind or a little bit rougher, right, at home. You're more relaxed. And we have to get out of that mentality if we're at home, and remembering that when we open the laptop or turn on the Zoom, that it's like walking through those doors at work. We have to maintain that same level of professionalism. So we'll try and talk about how all of this applies remotely. So before we dive into all of the details and information, we like to start with a few true or false questions. I used to do this training in person quite a bit, and it was a lot easier to do this portion of the presentation where I could see people raise their hands and see their reactions. And obviously that has shifted trying to do it remotely. But let's go through it because I think it's a really helpful exercise, and it helps us touch upon some important parts of this presentation. So the first is, are managers liable for the actions, if actions are within course or scope of their job, of individuals under their control? So our managers,
Excuse me, it's Diane. Excuse me. I'm so sorry to interrupt you, but I think we're looking at your last slide. I'm not sure that we can all see what you're looking at.
That's so interesting because I see true or false on my slide, but let me click one more time and see, maybe there's a delay. Did that work?
Unfortunately, it did not.
Well, it wouldn't be 2020 without some type of technical challenge here. Let's try it one more time. Diane, do you see true or false?
I do not.
Okay, well, let us start the show over again. And thanks everyone for your patience.
Here we go. Here we go.
Here we go. Now, do you see true or false?
I do.
Great. Okay, thanks for that. So again, are managers liable for what you as employees do? And I'll let you think about that for just a second. And the answer to this is true. They are, to a certain extent. When you're, again, on site or in a working capacity, which again changes when people are at home, managers are responsible for what you do, which is why there's a 2-hour manager presentation where we provide guidance on manager coaching and how to make sure they're maintaining and monitoring what employees are doing. But they absolutely are liable for what you do. They have a responsibility to make sure that those environments are safe. So your responsibility as an employee is to not engage in inappropriate behavior, and a manager's responsibility is to make sure that they monitor that employees are adhering to that. If your intentions are good, your behavior cannot be considered sexual harassment. So a great example of this would be if someone perhaps comes into the office, or maybe they're on a Zoom call and they perhaps got a haircut or they're wearing a new outfit, and someone's intent is to give them a compliment, but the way it comes out is by saying something such as, maybe looking them up and down at their physique and going on and on about their body, using sexual terms. Again, their intent is to give a compliment, but is that still considered harassment? And so the answer to this question, if your intentions are good, your behavior can be considered sexual harassment, is obviously false. So it's the perception of the behavior that determines whether something is harassment. So if a reasonable person, and we're going to talk a lot about the term reasonable, but if a reasonable person would look at a behavior or action or comment and feel that it was inappropriate and fell into the category of harassment, it doesn't matter what an individual's intentions are. So we have to remember that. It's also important to remember that we all have a wide array of what we find appropriate. So some individuals might be incredibly sensitive, and some individuals might not be offended by anything that is said. But in a business setting, we look at that middle area. We look at, well, what's reasonable, right? And so as employees, it's important to remember that you may work with a bunch of coworkers who you're extremely comfortable with. And so you might have historically been more free in your communication, right? Perhaps you told some interesting jokes or made some comments because you felt so comfortable with your coworkers. The problem with that is that if somebody overhears it, they may be offended by it, right? Or your coworkers' level of comfort may change as well. So it's really important that we remember as employees, no matter how long we've worked with these individuals and how close we are with them, that when we're working, whether it's on site or virtually, that we really maintain and strive for that professional level of decorum in communication, in your actions, and how you present yourself. Not being aware of current state and federal law is okay. After all, you didn't know. And obviously this one is false, right? And especially in California, where the legislation has changed and now everybody has to receive training. There's no, you cannot fall back on, well, I didn't know. I didn't know that harassment was not allowed in the workplace. Asking a coworker for a date is not sexual harassment. They always let this one linger a little bit because I get mixed responses. The answer to this is true, but there are two components of it, right? So in California, coworkers are allowed to date other coworkers, right? And what I mean is, in California, you cannot have a policy in your company or organization that prohibits individuals who are at the same level within the company from having a personal or romantic relationship. Now, as an HR professional, this is hard because we obviously never want to promote this because romantic relationships can get tricky. And actually, they say statistically that 50% of EEO complaints of sexual harassment do stem from consensual relationships that have soured. So we don't love this, but an organization in California cannot prohibit two employees at the same level from having a relationship. Now, a company certainly can prohibit an employee having a relationship with a superior or vice versa, when there's a difference in management level or authority. Obviously, you're not going to supervise somebody you're involved with. So that's absolutely allowed. So if you wanted to ask your coworker out, that alone is not necessarily harassment. The other component that you have to understand is how you ask a coworker out, right? Because that changes the situation. So I will use this example that I use sort of throughout the presentation. And that is, let's say you have two coworkers, Joe and Jen. And Joe sees Jen in the break room and says, hey, would you like to go grab coffee? Again, 2020 changes this, right? Because perhaps there isn't a break room and perhaps you're not going to grab coffee indoors, but we'll go with it. So he politely asks her out and she declines. And he leaves it at that. He does not ask again. Is that necessarily harassment? No. But if we change the scenario and he thinks, well, goodness, I'm not going to take no for an answer. I'm going to keep asking her and I'm going to email her or leave a post-it on her door, and it continues, is that harassment? Yes, probably. So in looking at this statement, it's important to understand the two pieces of whether or not there's a supervisory relationship and whether or not you've crossed that appropriate threshold, right, in how you ask somebody out. Men as well as women may be either the perpetrators or victims of harassment, and obviously this is true. And we're actually seeing an increase in the number of men filing harassment claims, and we don't attribute that to a surge in women who are harassing men. We attribute it to the fact that there are more women in supervisory relationships or supervisory roles. We also want to point out that with this statement, it doesn't have to be a male harassing a female. It can be a male harassing a male, female to female, and also those who don't identify with a particular gender. So gender doesn't really play a role in this. Anybody can be a victim or a harasser. And the last one, sexual harassment is only prohibited if it occurs in the workplace during working hours. And this one is obviously false. So again, prior to 2020, certain situations that were outside the workplace, outside working hours, might be a company holiday party. And back in 2017, we did see an increase in the number of companies decide around the holiday season to either cancel their holiday parties or decide to have a dry lunch. Obviously, alcohol can, muddy a event, and that was right around the time that there were all the allegations in the media, and people were very heightened about this issue. I've had a couple situations personally with my clients in which there have been events that employees have gone to that are not work related, right? One in particular was just a happy hour. A lot of employees and supervisors attended a happy hour on a Friday, which don't we miss those days, right? Wish we could go back to that. But unfortunately, something occurred during that happy hour. And so the question was, was the company responsible for it? And as you'll find with a lot of harassment laws, there is a lot of gray area, okay? Obviously, if it's on the workplace during working hours, if something occurs, it's absolutely the responsibility of your organization, and you should report it to your manager and to your supervisors and HR, or follow that protocol. If it's outside of that, however, my advice to you as an employee is to always report it. I won't spend the next hour talking about all of the different scenarios in which a company is responsible or isn't, because like I said, there is a ton of gray area when it comes to this, and lawyers will find a way to argue either side. But as an employee, I would say, when in doubt, always report it, because it's important for your company to be aware of it. And then your company, with their legal team, can review the situation and decide whether or not they're responsible. If you don't report it, they may not be able to provide the assistance that you should receive on this issue. So I won't go more into it than that, but I just really encourage employees, because a lot of times they think it's not, I wasn't on the workarounds, it was after hours, there's nothing they can do. I'm just gonna have to keep dealing with this uncomfortable interaction with this other employee because of something that happened on a Friday night. And I just really would encourage you to always let your supervisors and managers know. So quickly, as Diane said, there is a new law that has extended the previous requirement. So previously, California required that businesses with 50 or more employees provide non-harassment training to managers, right? Every 2 years, and the training was a 2-hour long program. That has shifted, and now the law requires that any organization with 5 or more employees, so much smaller companies, provide the same 2-hour training to supervisors, but also training to you as employees. It's a 1-hour program every 2 years. And this is directly from the Me Too movement. The Me Too movement last year, or 2 years ago, I should say, in California decided we were not doing enough. Just because we were training managers, that wasn't sufficient. That we had an obligation to provide training to our employees, right? And the training for supervisors is a little different because it's more of what their role is in trying to prevent and correct harassment. But training for employees needed to be centered around understanding your entitlement as an employee to a safe environment. To
Devin,
understand.
excuse me, it's
Sure.
Diane. I think maybe you intended to advance the slide, but I don't think it did.
Oh goodness, we are going to struggle with this. Okay, we're going to go back and end it and go right back to that slide again. Let's see if this works. No, it's
There
going to
you
go.
go. We're there now.
Okay, well, chalk this up to 2020, I'll tell you. Oop, I went too far. Okay. So again, the idea was that employees needed to be aware of what their rights were to a safe environment and also to receive education on how to conduct themselves. What is harassment? What can I do and what can't I do as an employee? And finally, if I'm a witness to something or if I'm subjected to something, then what? Making sure the employee really understood how to report it. A couple other components of the training is it has to be interactive. So again, a presentation like this where you can ask questions. Oh, my slides really don't want to work today. And then obviously the trainer has to have special requirements, either be a lawyer, subject matter expert, HR professional. So someone who understands what they're speaking about. Very quickly, federal law against sexual harassment evolved from the Civil Rights Act of 1964, and the Equal Employment Opportunity Commission enforces it. All this slide means is that you have protection as an employee at the federal level and at the state level. And we'll talk about how to file a complaint, but just to speak about it briefly now. If you experience harassment and you've reported it and you don't feel your organization has sufficiently handled it, you do have a right as an employee to file a formal complaint. And you can do so at the federal level with EEOC, and you have 300 days to do that. So 300 days from the date the incident occurred. If there's multiple incidents that you're reporting, it would be 300 days from the most recent occurrence of whatever you're reporting. And if you file with the state Department of Fair and Equal Housing, you have 3 years to report it. And those timeframes have all shifted in the last year. So it was a year and 180 days before, and now it's 300 days for EEOC and 3 years for Department of Fair and Equal Housing. So quite a bit of time to report it if you feel your organization hasn't handled it appropriately.
Excuse me, Devin, I'm going to jump in again, and I really apologize that I keep doing this, but I think we're having a problem with the slides because we're still looking at the one that,
Let me see if I don't do the full screen, if that makes a difference. Can you see this one, federal definition of sexual harassment?
Yes.
Okay, so I apologize if you see all the junk on my screen, but maybe we'll try that and maybe that will work. Is that okay?
Yes.
Okay. Thanks everyone for bearing with us. So the federal definition, if there's federal protection of sexual harassment, includes unwelcome sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature, constitute harassment when it does one of three things, right? When the conduct has some type of impact. So if it explicitly or implicitly affects an individual's employment, if it unreasonably interferes with an individual's work performance, or if it creates an offensive work environment. So let me go back to the example with Joe and Jen. And Joe continues to ask Jen out, and it's making her extremely uncomfortable. She is anxious when she wakes up. She doesn't want to go to work in the morning, and she decides, you know, I don't want to deal with this anymore. My company's not doing anything about it. I'm going to quit. Joe's behavior has now affected her employment, right? Same example, but let's say Jen decides she can't quit, right? The economy is tough right now. Everybody needs their job. But she is distracted at work. She's making mistakes. She's missing deadlines. She's always looking over her shoulder to see if Joe is coming down the hall to bother her. It's now impacted her performance. Same example, but let's change it a little bit. And let's say Joe and Jen actually decide to go out on a date and they're very happy together and it's all over Instagram and they're very serious. But unfortunately, they bring their romantic relationship into the work site. Maybe they're in the lunchroom and they're very physical and another employee sees it and is offended by it. Now their behavior has impacted the work environment. So it's important to understand that we don't just look at the behavior, the act, we look at the impact to the individual who is offended by it. What's the impact to them? Does it impact their employment, their performance at work, or just the general work environment? So in addition to protection both at the federal and state level for harassment, there's also protection from discrimination. And a lot of you are familiar with all of these, right? But just we'll go through the list. So California bans employment discrimination based on sexual orientation, gender identity, race, color, ancestry, national origin, religion, sex, medical condition, AIDS, HIV, disability, age, which is 40 and above, genetic information, marital status, military or veteran status, political affiliations or activities, and status as a victim of domestic violence, assault, or stalking. So what does this mean as an employee? Well, as an employee, your organization, your company cannot take a particular action against you, whether it's a poor performance appraisal, moving your office, again, if you're in an office right now, changing your work hours, your work assignment, just because of one of these protected categories. Now, companies can absolutely do all of that for a couple reasons, right? They can do it based on your work performance or the business needs of the company. And they should. Your managers absolutely should be making those decisions, but they should be doing so based on performance and needs of the company rather than personal attributes. So if you as an employee feel that your hours were changed just because you're 45 years old and perhaps somebody who's younger in the same role as you, their hours were not changed, you may feel that you've been discriminated against and you may have a claim for discrimination. Now, if your company gave you sufficient information to show that's not the case, that the other individual, for whatever reason, was responsible for X, and that's why X needed to be done at a certain time, right? Again, if they were able to show that it was because of business needs or your performance, then you may not have a discrimination complaint. And so you as an employee have a right to know why certain decisions are being made. If you get a poor performance appraisal, you have a right to know why. Hopefully they have documentation to show that you've been a poor performer. So just be aware that there is quite a bit of protection as an employee based on personal attributes. So it protects members in the protected categories, right? So if you absolutely fall into this category, you're protected. It also protects members who are perceived to be in this category. So going back to the age example, you may not be over 40, but if you're perceived by your managers to be older than 40, you could make that argument. And finally, it protects an individual who is associated with a person who has or is perceived to have any of the protected characteristics. So if you're married or in a relationship with somebody who has one of those characteristics and you feel that your manager is discriminating against you because of that, you are protected. So now let's talk about California's definition of sexual harassment. Again, it's very similar to the federal definition. Unwanted and unwelcome visual, verbal, or physical conduct that is sex-based or of a sexual nature, requests for sexual favors, or offensive third-party conduct to which the victim is subjected. And I want to talk about this last bullet for just a moment. So a lot of times employees think that when it comes to harassment law and protection from harassment, that it just extends between coworkers and coworkers. And that is not the case. So I'll give you an example. If you are, let's say you work in a large office that receives a lot of packages, right? From FedEx, UPS, all the different carriers at this point. And maybe you sit in the front and you receive those packages. And for whatever reason, the same driver comes every day and the driver flirts with you or makes inappropriate comments or some type of behavior that makes you feel uncomfortable. As an employee, do you just have to take it because the other individual is not an employee? Or are you protected? And the answer to that is you're protected. So when we look at how far that protection extends, it extends to the entire work site. And again, with COVID, remote working as well. So you as an employee are not just protected from managers and employees, but also vendors, clients, right? And we'll talk about that in a second. If a job applicant comes in and says something offensive, the idea is you look at anybody that comes in contact with your business or organization can be a potential harasser, and employees are protected from that. We will also see that it goes the other way, that businesses have an obligation to protect clients and vendors from their employees as well. So it's really important, again, when you think about it, when you walk into your office or again, you turn on your Zoom, that you are extremely professional in your behavior and your decorum, and you expect that in return. So there are 5 different types of harassment. Now that we've defined it, what does it actually look like? There's verbal, include comments, racial or sexual epithets, requests for sexual favors, jokes, propositioning. There's nonverbal, staring, derogatory or suggestive gestures, winking, throwing kisses, shunning, ostracizing. Visual, offensive pictures, photos, cartoons, posters, calendars, magazines, objects. Be very careful what you have in your office and also what you have at home when you're working remotely and what your camera sees. This extends to that. Just because you're on Zoom, if you have a piece of art that speaks to you but could be inappropriate and that's in your background, that could be offensive to other individuals. Physical, unwelcome touching, hugging, kissing, patting, stroking. Maybe the only good thing to come of 2020 is probably less cases of this, right? Everyone's keeping their 6 feet of distance. And the last one is written. Personal letters. Don't see a lot of those these days, but sometimes. Notes, emails, especially now where we're communicating more than ever, less face-to-face and more digitally, and we have that digital footprint. Please be very mindful about what you're putting in emails and texts, right? Which leads me to the next one. What is the latest issue? Sexual harassment. It's a little cheesy. I didn't make up this slide. You can blame my boss, but it is a very prevalent issue. I think it was just last week I had a case with a client where 2 employees who were friendly were engaging in text messaging, and at one point it shifted from friendly banter to really inappropriate comments. And the text messages impacted their ability to work together, and the company had to get involved, and there was some disciplinary action taken. So as employees, I know we're very quick to send off that email, we're very quick to shoot out that text. But remember a couple things, especially in a text, because it's a much more brief message. Your message may not be received the way you intend. I'm guilty of this with my husband. Half the time we get into a fight, it's because he read the text one way and I meant it a different way. We encourage clients, and a lot of clients are shifting to actually having no texting policies. Email's a little different because you do have the ability to use more words to get your message across, but it's the same issue. Sometimes you lose your tone. You write it one way, or you have a different writing style and somebody else receives it a different way. So remember that, and also remember that they live forever. There's no way to delete a text permanently. There's no way to delete an email. I can't tell you how many cases I've had where employees think they deleted it on their end, not knowing that the recipient forwarded it to me or took a screenshot, or even if they deleted it, that we couldn't go back with the powers of IT and find it. So please, please, please always remember to be careful. And a great rule of thumb, which is a rule of thumb not just for your written communication, but in general, in how you compose yourself or act in the workplace. And it's actually one of the slides at the very end of this presentation, but I'll say it right now, is to conduct yourself as though your child or your parent or close friend or your spouse, significant other, is watching. Would you say or text or act that way if somebody else was watching you? And would you be embarrassed? And if the answer is yes, if my 3.5-year-old who can't read saw mommy getting very upset, or if my mom read a text that I sent to a coworker, would I be offended? And again, if the answer is yes, then that means it's not appropriate. It's just kind of a good in the back of your mind way to remember that you really need to be as professional as possible when you're working. So we've talked about the types of harassment, and there's 2 broad categories of sexual harassment. So there's 5 types, but they fall into 2 broad categories. The first one is quid pro quo, and the second one is hostile work environment. So quid pro quo means something for something or this for that. It's the most obvious form of harassment. Typically occurs when a person with the power to influence an employment decision or condition seeks a sexual favor in return for a positive outcome. This was nicknamed in the 1920s the casting couch effect, The idea that if an actor or actress wants the part, they would have to offer perhaps sexual favors to get that role. So that's where this stems from. And obviously employees are strictly liable. We didn't think we saw a lot of these cases. We thought we saw more of the hostile work environment cases. And then what happened a few years ago? We saw all the news stories break out about Harvey Weinstein and all those cases, Matt Lauer in the news. And it really made organizations look more closely and realize these really egregious forms of harassment, sadly, are still occurring. Couple quick examples, because I want to be mindful of time. Sandy's manager, Matthew, asks her to have dinner. She declines. He asks again and says that there might be some discussion over dinner about a new role in the company. She's torn, but accepts because she wants the promotion. Is this harassment? Probably. Daniel's boss, Christine, makes frequent flirtatious comments when they're alone. He ignores the comments because he needs the job. She asks him to stay late one evening to work on a project. She asks him to give her a back massage and makes suggestive remarks about taking things further, telling him that he can avoid the next round of layoffs if he plays his cards right. And obviously, that's a form of harassment. The second category is hostile work environment. That's when an employee is subjected to sexual advances, requests for sexual favors, other verbal or physical conduct of sexual nature, or where non-sexual abusive conduct imposes a greater burden on one sex than the other. Obviously, the conduct is unwelcome and it has some type of impact, like the 3 levels of impact that we talked about at the beginning of this presentation. Does it impact the victim's employment? Does it impact their performance? Does it impact their environment? Or there's a 4th level of impact. Does it impact an employee's psychological well-being? So if we go back to this example with Joe and Jen, she doesn't quit her job. She's somehow able to focus and not let it impact her performance. But it doesn't mean it's not having an impact on her. Maybe she's losing sleep at night. She starts to see a therapist. She's losing weight, gaining weight. There's some type of impact to her. That would be used to show that it is a harassing behavior, that it has created a hostile environment. Another form of harassment is gender stereotyping. So negative gender-specific comments and stereotyping can lead to claims of harassment. So statements such as, that's a man's job, a woman could never handle it. Women are too sensitive to handle pressure jobs. Or men are pigs and can't be trusted. Obviously, you don't say these things, right? These are inappropriate. But can you say positive gender-specific comments? So can you say men are very strong, so they should carry these boxes? Or women are really good multitaskers, and therefore we should put Sally on this project? Maybe a few years ago you could, but now you can't. It's really important, especially when we look at individuals who don't want to be identified with a particular gender. We cannot categorize employees by their gender and make specific categorizations about their ability. So even if it's positive, and again, your intent perhaps is to give a compliment, right? Going back to one of the true or false questions, is it the intent or the perception? You can't make these types of comments anymore. Now, what you can say is, well, Sally, I know is a very good multitasker, so I'm going to put her on that project. Or I know that John has disclosed that he's a bodybuilder or works out and he likes to help lift heavy things. Probably a bad example, but you can certainly say that. You just cannot put them into the box of gender. So we've talked about this, so we're going to go through these next few slides very quickly. Who is protected from unlawful harassment? obviously you as the employee, the job applicant, independent contractors, third parties, customers, vendors, anybody that comes into contact with the business is either protected or could be a potential sexual harasser. So it's really important for you as employees to know that. I don't want you to think that just because they're not an employee in your organization, you have to somehow take whatever behavior it is they're exhibiting. And the really tricky one is clients. I get this question all the time. Well, we have a very important client to our firm, and he or she, or they, I should say they're very inappropriate with me, but they're also providing 20% of our revenue, so I can't complain about them. Is that the case? No. And when I provide this training to managers, we talk about that. We talk about, I understand that I'm here providing this lovely PowerPoint, but how does that actually translate into the real world where it's really sticky? And there have been clients who have had really important, or I should say my clients, there have been companies that have really important clients to them, and the clients become a liability to their employees. They're inappropriate, but the clients are also really important to their business. And sometimes the solution is to lose the client. Sometimes the solution is to keep the client, but not let the client have any contact with employees. And there's a lot of other creative solutions somewhere in between those two options. So I just want to highlight that because I don't want employees to think they're the most important client, we can't complain about them, because I do see a lot of questions and concerns stemming from that. So again, quickly, because we are running out of time, sexual harassment can occur in a variety of circumstances. Victim as well as the harasser may be a man, woman. Gender does not play a role in this. Harasser can be the victim's supervisor and agent of the employer, supervisor in another area. The victim does not have to be the person harassed, but could be anyone affected by the conduct. So in that example with Joe and Jen, when they were happily together, but a little too comfortable with each other in the break room, and the individual, another employee, witnessed it and was offended, that's an example of this. Anyone who sees or hears the behavior and is offended by it. Unlawful harassment may occur without economic injury to or discharge of the victim. So again, the idea that it can just impact the individual psychologically, and the harasser's conduct must be unwelcome. So quickly, employers are obligated to do two things, right? Employers must first and foremost take all reasonable steps to try and prevent discrimination and harassment from occurring, right? So that's why managers and supervisors attend non-harassment training. That's why all companies have a strong sexual harassment policy and procedure in place in their handbook and educate employees about it. That their focus really should be on trying to prevent discrimination, creating a positive environment, creating a successful culture to prevent harassment in the first place. And a lot of employees don't necessarily understand that. They think, well, we have a good system if somebody does file a complaint. And I want you to understand that it's so much more than that, that their focus as a manager, as a supervisor, should be more at how to prevent those situations from occurring in the first place. And then unfortunately, if they do all of that correctly, and sometimes this happens, and harassment still occurs, then obviously once they're aware of the alleged harassment, the employer must take immediate and appropriate corrective action, right? That means immediately find a way to separate out the employees, to do an investigation, figure out what happened, and take appropriate corrective action with whomever is being inappropriate. And that may range from disciplinary action all the way to termination. It just depends. But the idea is that you protect the complainant and the aggressor. In the initial stages, the company may not know what is what. So they have to protect both parties initially before they do an investigation, right? But the idea is that it has to be immediate. It can't be great, we'll look at this in a couple weeks. Once you as an employee bring a complaint to a supervisor, they have to address it right away. Your obligation as an employee is that you have to report it. Unfortunately, in California, you can't report things anonymously. You can't just refuse to participate in an investigation. If you see something or hear something that's inappropriate, you're responsible for reporting it to the supervisor or HR or CEO or any management official. Okay. Usually your handbook is going to outline the grievance procedure. It's going to spell out all the various people that you can go to, and there should be more than one person. In your handbook, you should make sure there's more than one individual that you can report harassment to, just in case that individual is the person who is harassing you or you don't feel comfortable going to them. And your other obligation is to cooperate. You do have an obligation to cooperate in any harassment investigation conducted by their employer. We want to recognize that it is difficult to report harassment. We do not want to take that lightly. We understand that employees might be worried that they're labeled a troublemaker, they may lose their job, or that it's my word against theirs, and that's a common one. Why am I going to report it when no one else was a witness to it and the other individual is just going to deny it? But please remember that you are protected from all of these, right? In addition to that, yes, there are laws protecting you from retaliation. There are laws protecting you from adverse action if you do report something. But what I encourage you all to remember is that less about that and more of, if you don't report the harassment, it's just going to continue, right? And even if you're okay with it continuing and you can just quote unquote take it, would you want your coworkers to experience it? I know a lot of us are very close to our coworkers. We care about them. Would you want that behavior to continue with them? So going back to the Joe and Jen example, if Jen doesn't report it, but she's really good friends with so-and-so, maybe Joe starts to turn their attention to so-and-so. So I just want to remind you all of that. We do understand it's difficult to report these types of behaviors, and a lot of people just think it's not worth it to me. We really encourage you to kind of remember that human side of it, right? It's for the greater good. We talked about this. Yes.
Excuse me, it's Diane, and I'm looking at the clock and I see we're quickly running out of time. So I wonder if there's a couple slides that you want to make sure not to miss in the time we have left.
I will, and I will do it. I will do the last 10 slides in 2 minutes.
Okay.
I promise. So we talked about this, your right to file, right? And actually, I apologize, this slide needs to be updated. It just changed this year, so it is 300 days for EEOC and 3 years for Department of Fair Employment and Housing. This is just a graph to show the number of cases that have been filed in the United States, right? And what's important to note here is that there was a huge uptick in 1991, and then it leveled out, and we expect to see another uptick in 2019 when we get that data in 2020, obviously given what's been going on lately. A few current statistics: at least 25% of women experience sexual harassment in the workplace. 87 to 94% of employees experiencing do not file a formal complaint, which means the numbers we just saw in the graph are off by a lot because people are not reporting it. If you're a woman, you have a 60% chance of experiencing harassment, and if you're a man, you have a 20% chance of experiencing harassment. So obviously, this is extremely prevalent. The last two topics in the last minute: abusive conduct. Abusive conduct is bullying, right? Defined as conduct with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. It includes derogatory remarks, verbal or physical conduct that a reasonable person would find threatening, and the gratuitous sabotage or undermining of a person's work performance. Other signs of bullying are verbal anger, nonverbal aggression, like slamming something on your desk, punishing you, belittling you, humiliating you in a staff meeting. All of these are part of harassment and are all things that you should not be subjected to. And the last topic is retaliation, which we talked about. This is when an employer takes adverse action against an employee because he or she has either complained of unlawful harassment, participated in an investigation, or is associated with someone who has complained. So you might be really close to a coworker who is involved in this muddy harassment claim, and something happens to you and you feel like you received a poor performance appraisal because your company was mad that you were associated with this individual who had filed the complaint. And so you can raise the claim of retaliation. And both retaliation and bullying are things you as employees are protected from. And this is the last slide, and I'm 1 minute over, and I apologize, but we talked about this. And it is the idea that you remember, is this something that you would want a parent or a spouse or child to see, hear you say or do, right? And if it's not, then it's not something that is appropriate in the work site or when you're virtual and working and dealing with coworkers. And with that, I'm happy to stay on if there's questions. I appreciate you guys being patient with us as we kind of work through some of the technological glitches, and I apologize for being a few minutes behind. If you want to email me questions, I'm happy to address them that way. But if not, Diane, I'll let you know if you have any questions in the chat box.
So thank you, Devin, first of all, for an outstanding presentation. Really, you did an excellent job, irregardless of the technical issues that we seem to all have. Since we are out of time, I want to let everybody know that in your follow-up email that you will receive at some point after this webinar, it has Devin's contact information. So I apologize we weren't able to get to your questions, but feel free to email them to her, and Devin or someone on her team will respond to you. And I also just want to say thank you so much for taking advantage of this training that we're so happy to provide complimentary. And a reminder that next Wednesday from 9:30 to 11:30 a.m. we'll do the managers training. So thank you, everybody, and have a terrific day.
Thank you, everybody. Take care.
Bye.